Question number 32, which asks, what are the privileges of the administration in suit? And that very answer, as we discussed, though the equality clause of the Constitution envisages absence of any special privileges to anyone, including government, but since government is a government in contradiction to a private individual, law allows certain privileges to the government as a litigant. From among the numerous privileges available to the government under various statutes, a few important ones maybe will discuss in the very context of answering this relevant question. So, one of them is the privilege notice. So, Section 80, Clause 1 of the Civil Procedure Code 1908 provides that no suit shall be instituted against the government or against a public officer in respect of any act purporting to be done by such public officer in his official capacity until the expiration of 2 months next after notice in writing in the manner provided in the section has been given, and the very requirement of notice is mandatory and admits of no exception. So, as it was decided in the leading case, Swami Singhal versus Union of India in 1966 by the Supreme Court. However, if the public officer has acted without jurisdiction, the courts have held that the requirement of notice is not mandatory. Therefore, if a public officer seizes property without authority or assault a witness, as it was held in the leading case, Raneshwar Prasad Singh versus Muhammad Ayub in 1956 by the Patna High Court, and in Datta Rai versus Annappa in 1928 by the Bombay High Court. No notice is necessary for filing a suit against him in his official capacity. The Allahabad and Calcutta High Courts have further held that notice is unnecessary when a public officer, though acts within jurisdiction, but in a malified manner. The requirement of notice may also be waived either expressly or impliedly by the government, as it was held by the Andhra Pradesh High Court in 1978 in the leading case Shiva Ramakrishna versus Executive Engineer NCG. So, the second one is privilege of withholding documents. In India, the privilege for government to withhold documents from the courts is claimed on the basis of Section 123 of Indian Evidence Act 1872, which lays down that no one shall be permitted to give any evidence derived from unpublished official records relating to the affairs of the state, except with the permission of the head of the concerned department, and who shall give or withhold such permission as he thinks fit. So, Section 124 extends this privilege to confidential official communication. This privilege, if claimed, is not conclusive in the sense that the courts can do nothing except to admit it. This proposition is based on Section 162 of the Indian Evidence Act 1872, which provides that when a witness is required to produce a document, he must bring it to the court and then may raise an objection to its production and admissibility. So, in the very leading case, State of Punjab versus Sudhi Sukhdev Singh in the year 1961, the Supreme Court had held that the opportunity of discussing the extent of government privilege to withhold document where the claims of governmental confidentiality and individual justice compete for recognition. Also in Indira Nehru Gandhi versus Raj Narayan in 1975, Supreme Court compelled the production of blue books of the police and disallowed the claims of privilege. And also in state of Odisha versus Jagannath Jena, the Supreme Court disallowed the privilege on the ground that public interest aspect had not been clearly brought out in the affidavit. So, these are the privileges of administration as provided under Section 80, Clause 1 of the Civil Procedure Code 1908, so also Section 123 and Section 162 of Indian Evidence Act 1874, so also Section 124 of the Act. And regarding the very observations made by different high courts and the Supreme Court, we discuss certain important decisions and observations as made by the apex court or the Supreme Court in the important leading cases such as State of Punjab versus Sudhi Sukhdev Singh in 1961, so also another most important leading case, that is Indira Nehru Gandhi versus Raj Narayan in 1975, and so also those relevant decisions tendered by some high courts such as the State of Odisha versus Jagannath Jena, and also relating to Swami Singhal versus Union of India. So, also the very decisions of Allahabad and Calcutta High Courts and Patna High Courts. So, hereby we complete the very relevant answer which is most appropriate regarding the question what are the privileges of the administration in suit.